The Ohio Public Records Act, also called a Sunshine Law, provides public access to records and is meant to foster the spirit of open government. Any person may request to inspect or obtain copies of public records from a public office that keeps records. As a public institution, The Ohio State University follows the requirements of the Act and provides copies of existing records that are requested within a reasonable period of time. In this presentation, we will explore what faculty need to know about public records. Almost anything can be a public record. In fact, everything that in any way documents the organization, functions, policies, decisions, procedures, or operations of your office is a public record, regardless of the form in which it's maintained. This includes email, documents that are marked confidential, many draft documents, salary and compensation information, personnel files including promotion and tenure files, faculty and staff search committee files. And of course, there are exceptions, most notably, education records of students under FERPA, records related to disabilities and ADA accommodations, medical records, for example, those that are generated and maintained in the process of medical treatment, Social Security numbers, attorney-client communications, intellectual property records, and trade secrets. However, not every piece of paper on which an employee of Ohio State writes something is a public record. Personal notes generally do not constitute public records if they are not shared with anyone. Such personal notes do not meet the definition of a record because they do not document the organization, functions, etc. of the public office. But the moment those notes are shared or filed in shared files, they become public records. You may be thinking it's unlikely you would ever be involved in a public records request. And you're right. Most faculty never deal with this. But remember, anyone can make a public records request for almost any reason, and here at Ohio State we have hundreds of public records requests a year. While there are many reasons for the media or the public to submit public records requests, here are some typical types of requests that could affect you as a faculty member.
I am an associate professor up for promotion to full. I learned that my peers voted against my promotion. I want to see the external letters that were solicited, and I want all documentation from the meeting where the vote took place. I am submitting a public records request to the chair of the Promotion and Tenure Committee.
I was the chair of a search committee last year. One of the candidates from another university has submitted a public records request for all documents, evaluations, resumes, emails, and personal notes related to the search. Fortunately, there is protection of personal information in public records. Before releasing records, information such as Social Security numbers, addresses, information about minor children, account numbers, and employee identification numbers are removed. There is also protection of intellectual property. Research, manuscripts, designs, and artistic works fall into the category of intellectual property and are not public records, so long as such records have not been publicly disseminated. Also, the university, when reasonable and possible, will notify faculty and staff named in a records request. And there are standard precautions that you can take. In promotion and tenure committees, it's always a good practice to keep sensitive matters out of emails. This should be seen as a best practice in all cases. Do not put anything in an email if you're concerned that others could misconstrue it or if you do not want someone seeing or publishing it other than the recipient. Face-to-face conversations and phone calls are not records and often avoid confusion or embarrassing language that might find its way into an email. Keep in mind that very little is truly confidential once it is written down. In the case of the search committee, personal notes related to the search were requested. Personal notes that are truly personal and have not been shared with anyone are not public records. Again, if you share those notes or put them in a file that can be shared, They become public records. Again, exercise good judgment around what is written down and filed. Of course, there are guidelines to retaining records. As tempting as it may be, you cannot simply throw all your records away to avoid complying with the Public Records Act. All records should be maintained and destroyed in accordance with established records retention schedules. Most departments have staff members trained in matters of records retention. Find out who that is in your department and ask for specific guidance on what can be destroyed and what needs to be saved. Again, practice good judgment when committing anything to a record. The best way to treat public records is to know that you have not put anything that could fuel litigation or be embarrassing to you or the university in some format that could be public. Remember also that files kept by supervisors containing employment-related information may be subject to public disclosure. These files should contain factual, not subjective information. And finally, know that the Office of Legal Affairs is your best authority on handling public records requests. They are also the best authority on ways in which you are protected from revealing personal information. To read more about public records, go to the website of the Office of Legal Affairs.